can't mention any client without their express permission. So like you win a Supreme Court case for them, and like you often can't.
Where's the word enforcement? That they,
So you can't
it's
say
not in
about
286. What?
another case
No,
because
and
it
like the
directly
first,
mentions the client.
the first case I argued was.
They were trying to figure out, I think,
Marvel was part of Disney.
whether it was
and
part of the
Marvel was
unenforceability
like one case, we could
defenses
put it on our
or not.
website.
So
Mhm.
could you say,
I'm-
Tom Saunders is speaking at AEWCL today? Or do you have to-
Yeah, we can say
address
that.
it?
We can say that.
Hey, how are you? Good to see you. Thanks for coming. Very good to see you again. Thanks for coming.
Hey.
Basketball.
Yeah, I was actually just wondering, because I saw the references, so like, could I technically like share this on Facebook, this event?
Yes,
Or would I
please.
have to,
All the time. Every
I
single
know
one.
you guys would be okay with it.
Twitter,
Just whether I need to run
Facebook,
it by,
LinkedIn, all of it.
anyone at the firm. Our
I
malpractice
can't find your.
coverage, as I recall, is pretty strict about, or
What?
we have the instance of our malpractice carrier adopted fairly soon. So
Yeah, I can't find it.
There's a lot of people who've gotten themselves in trouble that way.
Also, the case before ours, now granted, was sort of breaking the seal in the False Claims Act case, but it was, the lawyer talked to the press, and the debate in the case is whether the entire case should be dismissed, or whether it was just sufficient that he had been disbarred and had gone to jail.
And that was
For
the
other
guy that talked to
reasons.
the press.
Yeah, he didn't get disbarred and go to jail because of talking to the press, it just happened to be committing on him.
It's Dickie Scruggs.
Yeah.
He had a lot of, he had a long rap sheet.
Yeah.
Not sure much of how much, but they actually nailed him for it. Yeah. But yes, now, I mean, there are plenty of firms that talk to the press, and some that view it as part of the service. We've never really done that. We generally ask the client to give us somebody to refer to somebody, it's one of their PR people, if they have outside help on that.
So I know a lot of people at your firm, a lot of associates have left in the last couple of years. But Mike Guzman's a good friend.
Oh. Yeah.
Mike, who is that name?
No?
Mike Namelka.
No.
Yeah, good partner.
So Tom, are you all
Yeah,
appellate or patent shop?
I'm
Both of them are
all
very
appellate
nice.
and
Okay.
mainly patent
Okay, so
appeals.
both of them.
Yeah.
Oh, of course, we're small. Okay, it's with everybody.
Just because we have,
It's
growing.
yeah, we now have hit,
license.
when we do Promega in December, we will be the Merits Council 11 of the last 22 in the Supreme Court patent cases. So that's what occupies a huge amount of time, and then we do a ton of federal circuit appeals.
Yeah.
So I mean, I
We
do
don't have
other
official departments
things
or
and have
something
other
like that. We
things
have
going
folks
on,
who
but
do
that's
more
sort of my main interest.
We have a couple of
And
folks.
we've discussed this before. You
I
had
know one
some sort of a
associate
patent background
was a clerk.
before?
Not-
Or you came in as an appellate person?
Yeah, I came in as
Drew
an
to-
appellate
Drew
and
to
government
patent
public
cases,
policy.
right.
Yeah, and just
So,
very
but I
interesting.
got that happens too much.
Hey,
Don't, a lot of them, they're coming up on these fundamental issues that we're all seeing, all bubbling up at once, so there's some stuff.
do you deal a lot with the Kavanaugh group, the real patent people?
Yeah, I was just on a phone call with him today, because because lots of the federal circuit appeals are coming out of IPRs, and he and I
I would
worked
say
on
the
other
folks who are
appeals from
doing,
district
like
together.
intentions, that's not the case. That's very special.
So he teaches here.
It's more likely to be something like,
I don't know.
is that what he's doing?
Yeah, Miles, I don't know his last name, he was a clerk at Johnson.
Oh, sweet.
So,
I've worked with him, but.
Yeah, I don't know how he has time.
He has less and less, you know,
He
but
really
that's sometimes how these teaching gigs go.
Right.
I think he's
Yeah, a little bit of
co-teaching it
turnover
with someone, I
these
don't
past
remember.
couple
Yeah. No, it was mainly just
That's
as his
typical.
sort of IPRs exploded, his schedule became very different.
Take a few years to sort of figure out what they really want to make the livestock control.
Yeah, that's
And,
definitely
you know, so, no, that's great.
big growth there.
Yeah.
Home
Yeah,
structure.
I know Chris Walker, who went teaching.
Less satisfying appeals.
Chris
They
Walker.
often just come up in very fact specific.
Yes.
Oh, there was an obvious question, and they're just going to go
What's that?
for
Sure.
it. Yeah.
There been anything interesting
Probably
go all the
should.
way up through that process yet? I mean, eventually
Just
there'll be some
close
interesting
out.
admin
Yeah.
Ramos, Gilbert.
We have an interesting
Ramos,
case, yeah, we have a case that's bubbling up where it's the first case
I was on it at the same time.
where they
Oh,
exercise their discretion
Josh,
in
yeah,
IPR to just terminate an ex parte reexamination. So it's sort of a fight.
Yeah, no,
within
he's
the office.
right. We don't get much cases.
It has a sort of substantive
Sorry,
issue in
Liz,
the case,
but
and
I think he's-
it's obscure. The dynamic drinkware decision the federal circuit decided in terms of
he actually had a real
how
time,
you're, how you're burrowing back to earlier versions of your patent application and getting written descriptions for the claim. We had the board extended that, so we're going up on
Was
the
it
sort of question.
Josh was-
Question of saying like that watching the law.
Yeah.
Most of the time, it's just
Talking about
was
it,
it
but,
was it obvious to combine A with B?
Hey, how are you?
Good. How are
Nice
you
to see you.
doing?
Good.
See you. This is Jack. He's working with me at Fish.
Hey, how you doing? Jack Wilson. Nice to meet you.
Great, you guys are fish?
Yeah.
I heard Cheryl left.
Yeah, that was kind of sad. She left before we even started.
Right,
so I haven't
right
seen
before.
her. I've heard rumors she might be considered.
Yeah.
Oh.
Yeah, keep your ears open.
Speaking of my patent class, next Monday.
Okay.
So I'm,
Yeah, you definitely should.
District court versus appellate court. We'll see.
it's Greg.
Yeah, 'cause
He works at Kelly.
Hi, Laura Whitworth.
Zerko, despite
Jack Wilson.
two opinions on it,
We should start.
Start officially in 15 minutes. You guys have a little bit to go.
different things to say.
you know the history. Right. What was your read on there?
I just didn't think, I mean, there's so many questions for the other side.
Well, I mean, maybe there's some.
I'm not.
Oh, yeah.
I guess maybe it depends on what your expectations are. I felt like there was a big hill to get over with the trial to begin with, and at least they were open to discussing the case,
Yeah,
with the exception of Justice Ginsburg.
right. I mean, I just, yeah.
If I can get you to sign in, I had emailed you because pre-registered, but I had ran a name badge, but I need, if you could just sign in for me, no rush, but whenever you're leaving, if you just sign. Thank you.
You had your eye on the lead on?
Okay.
You don't think there's a shot for this?
She seemed, I mean, she seemed
But I mean, if you're to the list that it is.
We have one more copy of the transcript. Does anybody want it?
so that, yeah.
Copy the transcript?
This,
Want it?
I know.
yeah.
This
Okay.
one's already on. This one.
Oh, is it? Okay.
That's how we have it.
They don't show up on the web,
But
but that's,
Absolutely.
well, I could do, yeah, there is a way to do that. That's what I'm debating, is try to slide the table this way.
Right.
I'm thinking about dropping that screen so you can see the statute.
Yeah. It's, it's
But I think,
nice.
I took her to be talking to you about the general.
Video.
I mean, she clearly thinks the general.
The webcast is referring to things that they can
We
say.
can definitely move
Yeah.
the table to,
I thought the most.
Yeah, I feel like so that people in it.
we can move it to this line for sure. Not all the way to here, but the camera cuts out about right there.
So.
Want me to push the other end?
I pulled my back, so if somebody can help me.
Just hold it. Gotta keep off the others. We have one more.
Eye that, does that look good?
I think it's-
Yeah, we're lined up on this.
I think that's probably good image-wise to line it up.
I didn't.
I'll stay in.
And then I don't know exactly how to get that, do you know how to get just that one down?
Yeah.
I wasn't sure who the available
Video.
and I was sort of waiting to see
Even
whether
sitting
there was
in the
anybody who
audience,
might do that. And I think it
And
was
the
that
lights are
message that said my errand. So I'm assuming.
Yeah, it's kind of a weird design.
Hey, this is Mike Carolyn, NTO.
So I don't think it's.
I want
Louis Thomas.
to drop the
Right.
lower right screen.
So I wouldn't say it's in the bag by any means. But
No, in retrospect.
Page right.
Which left surface.
Hello, hi, I'm Christine. Sorry.
Hi.
Professor here.
Great, great one. Nice to meet you.
I good to see you
Hi,
again.
nice
Such
to
as
see
in
you again.
Chicago, I think.
Yeah, yeah.
Is that clockwork?
Thanks for coming to this.
Yeah.
He said that the argument wasn't, there wasn't a lot of it.
Yeah.
There wasn't a lot of action, like, no.
The Supreme Court was kind of,
Really?
Well, there were two people who were talking a lot, but they were committed votes, so they were.
Yeah, it doesn't.
Yeah.
It doesn't
It
count
doesn't
if
count.
Justice Ginsburg and Justice Breyer ask all the questions.
Right.
And everybody else is just.
The ones who count are quiet.
Yeah.
Right.
Yeah.
They also had the interesting fight about the median trial
yeah.
Which is Breyer's like, I understand Bertrand is a piece of the majority of this decision, I understand based on this. And then before the
that's
third Justice
interesting.
Ginsburg jumped in and gave her a spin on what she was saying.
Oh, that's pretty interesting. Okay, that's pretty
Yeah.
nice.
Just to see.
They were trying to say.
Do you know where they were talking?
That is true.
I know.
So I'm trying
They were not shy about. I think they both feel like this is a refight of the same battle, maybe on maybe slightly different ground.
So I think,
the other side. Just the lower right.
well, there's maybe
One thing.
either of them.
Yeah. Oh, yes, certainly.
Well,
You're right. Ginsburg is deciding.
yeah, she probably signed this.
I tried to, but no.
Yes.
Yeah, although he said like.
Was it the first or second? Second.
That's the, you got the upper
What
right,
was the first?
upper left, upper right.
Exact, whether you talk to the media.
Oh, yeah.
No,
Perceivable oriented.
Hard to do one thing.
Sure why it's not lower.
Look pretty good later by the end of that argument.
Like everyone else is lower.
They're they exalted themselves.
Beating up on poor things.
Great.
She was tough. She was, because she got a grant. When she was fighting for since very.
Getting a little bit.
This.
Check
Yeah, I think it is when the system asks for it, instead of getting
That's- Second getting close
and I
to
think
that
that like the dynamic was, that was a little bit too soon, but that's pretty much. Like, wait for one of us to ask the question, Mr. Bash, but then tell us how we should write it.
Oh, yeah?
Yeah, paper idea, or did you put the
Yeah.
So these are your slides? Joe?
Okay.
Yes.
Yay.
Additional, who's on the bill, sorry.
Yeah.
Nice.
Come on.
286.
So we want webcast for the speakers. And right now, very long delay. So
That did
That
not
hung
get
everybody.
it's like,
They get very confused out of it. We don't have to run on that. In fact, we didn't run on that. It's still one thing.
I'd say 7 tossings.
I
Yeah,
other people care about this. So what did they say before?
A lot of good arguments, but.
You know?
It's just, I mean, if you think that these signals by the list are off, for damages, well, if that's not sufficient, then that was right. We have to have more nuance. There we go. But it's,
What are you looking to do?
Well, I was trying to use my finger. I'm just going to make this into a full screen.
Oh, I thought I had it, yeah.
But usually you can see the next thing there, but
Yeah.
oh.
See that?
No, we got it.
no.
Maybe there's.
Right.
They did such a good job with the number.
I don't buy so they had to realize case I don't want to.
Yeah.
That screen down.
No. Well, that's a section.
Yeah, it's in text.
Person,
We don't need it. We don't need it.
reference. No, I just was like, so let me.
I mean, because you don't need a sign.
Yeah.
It's the reference to enforceability there.
But I'm here.
No, it's just trying to.
There I am.
I understand what it's talking about.
I was just, have you guys met Megan? So she's a civil procedure technician, so the blonder tongue thing, I was just trying to understand what the non-mutual stuff is.
We were trying
So were the justices.
Yeah, so were they.
Was it very?
No, it's to try to capture my back to a time when it actually allowed you to turn around and see the next person.
Right.
I don't think they understood.
But it's definitely better.
Just because we're vendors.
I bet you.
But she wasn't being helpful.
Yeah, she wasn't gonna share that.
First.
I think they started to listen. We're not on the
Put it
mics.
all the way in the back.
Well, because if it weren't,
Are you?
The lights.
Yeah.
Do you want to drive since you made the slides?
No,
Your point is just, so Kennedy didn't.
no.
Great.
These three are the centers.
I see. I was trying to, there we go.
I did several years ago.
Everybody's phone set to stop.
Yeah, that's what I was just checking. I think I'm gonna modify it.
How's it look? Yeah? Okay. All right, good afternoon. Welcome to the program on information justice and intellectual property's ongoing Supreme Court series, where we ask counsel and for the parties and amicus, friends of the court, and other observers to help us understand what the court was working with in the morning of the oral argument. Today's case is SCA Hygiene Products Aktiebolag versus First Quality Baby Products, LLC. And the issue the court was dealing with today is whether the express time period for time limit, or the express time for bringing suit in the Patent Act, is the exclusive source of law with respect to how long a patent infringement case can be brought, or whether the equitable doctrine of laches can be used to bar a suit. We have a distinguished panel, and I'm excited to introduce them all to you. To my immediate left is my colleague, Professor Jonas Anderson, who is our patent law expert here on the faculty. He practiced in the area before joining our faculty and has now been with us in his 6th year of teaching. He also teaches property, so I have some of my first-year law students in the audience, and you may end up with him as your property professor next semester. To his immediate left is Greg Rappaway. He's a partner in the firm of Kellogg, Huber, Hanson, Todd, Evans, and Feigl, PLC. He represents clients throughout the litigation process at the trial, appellate, and Supreme Court levels. He's been with us before for a prior case. And litigates in a broad subject matters, including complex civil litigation, securities, enforcement, administrative law, and occasionally patent law. And he is counsel for a group of friends of the court representing Dell, or with Dell as the lead amicus. And when you file a friend of the court brief, sometimes the court may not read it. Sometimes they may ignore it. Today, Mr. Rappaway's brief got extensive discussion from at least Justice Breyer. To his immediate left is Professor Megan LaBelle at the Catholic University of America Columbus School of Law. Professor LaBelle is also a patent law expert and a civil procedure expert, and is particularly interested in the intersection of civil procedure and patent law, which is exactly what this case is about. And to her immediate left is Thomas Saunders at Wilmer Hale, who is the counsel for the respondent in this case. His partner, Seth Waxman, did the argument before the court. And so just a little bit of setup, and then we're going to be off to the races. Supreme Court has been hearing quite a few patent law cases for a variety of reasons. One is that there is only one federal court of appeals that hears these cases, the Court of Appeals for the Federal Circuit. And the Supreme Court does not get the benefit of a circuit split as a basis for deciding when an issue is ripe for review. Instead, when the Federal Circuit takes an issue en banc, and there's a sort of internal dissent within the court, that becomes a signal that there's an issue that Supreme Court needs to resolve. In addition, this case can't be understood in isolation. In the last term, in the 2013 term, the court heard a copyright case called Petrella versus MGM Inc. involving the film Raging Bull. And in that case, the issue was whether a claim for copyright infringement could be brought where the infringing acts had occurred decades before, and the plaintiff wanted to claim that within the prior 3 years, she should be able to recover her infringement damages, even though she had waited so long for the lawsuit. The Copyright Act provides for a 3-year statute of limitations, but the equitable doctrine of laches, also known as sleeping on your rights, estoppel is a separate doctrine, but the idea of laches is if you do not enforce your rights in such a way that it leads another party to believe that you won't, the equitable doctrine would say you waited too long, it's unjust for you to essentially trap the unwary with your lawsuit, and so equity will bar it. And the legal question was whether that equitable defense to an infringement action is available when Congress explicitly states a time in which an action can be brought. In that case, it was written by Justice Ginsburg. It was a 6-3 decision with Chief Justice Roberts, Justice Kennedy, and Justice Breyer in dissent. And we've lost Justice Scalia, so we now have a 4-4 court. The relevant section in this Patent Act is on the board, and it's except as otherwise provided, no recovery shall be had for any infringement committed more than 6 years prior. The parties dispute whether it's proper to call this a statute of limitations provision or not, and they'll explain why. But in this case, the question is, the lawsuit was brought within this time period. May the defendant raise the equitable doctrine of laches to bar the suit nonetheless? based on the patent owner's conduct. And so having answered the question in Petrella that the statute governs and that latches cannot bar a suit within the statutory period, why isn't this already answered? I will ask our panels, if that was the rule for copyright law, what's different about patent? The last thing I'll say is the Federal Circuit has routinely said patent law is special, patent law is different, patent law is exceptional. And the Supreme Court keeps, in almost all cases, not all, disagreeing and saying the general provisions of law apply equally to the Federal Patent Act. And the question is that trend going to continue, or might the justices truly find something different about patent law this time around? So here we are. This is our court, and I'm going to leave us with the statute on. And Professor Anderson is going to step into the petitioner's shoes and explain sort of the position the petitioner took in this. Then I'll ask Mr. Saunders to explain the respondent's position. And then I'll invite Mr. Rappaway to sort of explain why his brief supplements or adds to the position Mr. Saunders took. And then Professor LaBelle will give us her view, sort of overview. So Professor Anderson.
Great. Let's see here. So the argument for the respondent is pretty simple. Petitioner is pretty simple. If you look back at what happened in Petrella, this is a case that makes a big difference that Justice Scalia isn't on the bench anymore, because Justice Scalia would definitely be on the side of the petitioners here, and without Justice Scalia, it's 5-3 in favor of the side of the petitioner's side. So that's 5-3. They need to flip one vote essentially, and to make it a 4-4 split, and then the Court of Appeals rule stands. That's essentially what they're trying to do is influence one justice to say Petrella is different than this case at hand. And we have a whole host of reasons that why this case might be different, but that's essentially what they're trying to do. They're trying to get at least one justice to say, no, I don't think this case is controlled by Petrella, and it's different in that sense. So the big difference, what the petitioner is arguing essentially is that 286 says you can only get the damages for 6 years, the 6 year previous to filing suit. So a patent lasts 20 years. So if you file at year 6, you get all 6 years. If you file at year 10, you get years 4 through 10. You can only get the 6 years prior to the suit. And their argument is, look, that is Congress's attempt to try and cabin the amount of damage you can get, and latches would be an additional cabining of that damages, and that's too much cabining. And so this is what Congress intended, what they declared, and they don't include latches in how 286 is done. So that's really the argument, and also they're kind of arguing that patent law is the same as copyright law. If you look at Petrella, that's a copyright case, but it's latches. It deals with pretty much the same issue, and they're saying, look, patent law shouldn't be different than copyright. They're both law. They both have latches is an equitable doctrine. It's an old doctrine. It applies broadly across areas of law, and patent law shouldn't be exceptional in how it handles latches. And for that reason, Petrella should guide what happens in this case.
Pretty simple. Mr. Saunders.
Yeah, no, the respondent's response here was largely that, Petrella would be on point, except for we have small things like different statutory language, different history, and different policy here. And the main thing is, I think the history is very important to understand here, which was that in 1870, Congress passed a statute that made damages available in equity. And what happened from that point forward was people overwhelmingly would file their patent infringement suits in equity, because it was the place where you could go to get both an injunction and to seek damages. And so we presented a lot of the statistics in our brief, but you go for decades and decades where the vast majority of the action is in equity. By the time you reach 1952, you are putting up year after year in which 98% of the cases are in equity. And this is very important to understand because this is one of the reasons why modern patent law is infused with equitable principles, because during this formative period, it was courts of equity hearing these decisions. And a lot of our case is about this history and what Congress's understanding was in 1952, and the fact that it's really late in the day here to be unscrambling the egg. We're not going to come in and say that inequitable conduct, a doctrine that was formed in this period, suddenly wouldn't bar you from getting damages. No, of course, it has become a general doctrine. So we march through the history and show that every court of appeals to have considered the question during this period was applying latches. And very critically, the precursor to Section 286 was on the books from 1897 on. And it wasn't a traditional situation where you had a statute of limitations at law and latches was just filling the gap on the equity side of the court. The precursor to Section 286 was actually put in the equity side of the statute and had general language, so it applied both at law and equity. So what you had is you had essentially 5 decades of courts sitting in equity with a statutory period cutting off, no more than 6 years of damages, but also determining that that was perfectly consistent with continuing to apply latches, which they did during that period. And so then you come to 1952, where Congress is sort of, except for a few express areas where it's trying to change the case law, what we're talking about here is an exercise in codification. It's trying to take the strands of the law, some of which are scattered in statutes, a lot of which is judge-made, and putting it all together in the statute. And the one unfortunate thing for us in this case is that when Congress chose to do the defenses, it said what we're doing here is we're using generalized language. So past the statute says you have a non-infringement defense, you have an invalidity defense, and then they inserted an unenforceability as a defense in the statute. P.J. Federico, who was the sort of principal draftsman of the first draft of the Patent Act, had a very influential commentary, which the Supreme Court and Federal Circuit have relied on, in which he says unenforceability was added to the statute to encompass latches. And so we think this is just a classic case of codification. There was a uniform rule in the courts of appeals, and then Congress was just trying to enshrine the law as it found it, and it was doing so through this unenforceability provision. The main headwinds we'll run into, and we can sort of get into some more discussion about this, is because they chose an umbrella term to cover a bunch of different things, latches, patent misuse, inequitable conduct, it left us without the specific word latches. And then 2, I think the court was grappling a lot today with what does it do with lower court precedent? Because often in codification situations, you'll be codifying a Supreme Court case. Here, the Supreme Court never had an occasion to address the rule because no one was disagreeing about it. So we say that's very powerful indication that the law was settled. But the other side in the case says, well, it wasn't the Supreme Court, so how do we know that Congress was looking to lower court cases in this circumstance?
Great.
Okay. So Tom's brief, for the party focused obviously on the traditional tools of statutory construction, text, structure of the statute, and history. We as amici we represented a large group of companies, largely technology companies, but also a number of manufacturers and retailers, all of whom either have been or have reason to fear that they will be exposed to liability for patent infringement, or at least charges of patent infringement. Came in with a brief that was intended to shed some light for the court on the more practical consequences, and in particular on the modern day practical consequences of abolishing the doctrine of laches and allowing patent holders to wait as long as they liked within the term of their patent to bring their suit for their 6 years of damages. And our brief began with a series of case studies, some of which involved our amici and others were just recent cases that we found through our research that showed how companies can have defendants who are accused of patent infringement can be placed in an untenable and, in our view, an inequitable position by this problem of unreasonable delay, because evidence can be lost, because many of the defenses that are crucial in patent litigation, like invalidity, require you to prove things about the state of the world at the time that the patent was issued, which is a lot easier to do early in the patent's life than late in the patent's life. And so you have those types of evidentiary prejudice. You also have various forms of economic prejudice that can occur as a result of unreasonable delay. And there we talked at some length about the problem of lock-in, where a company starts to use a patented technology, maybe not knowing that it's patented, or not believing that it's ever going to be sued for patent infringement, makes investments, potentially very large investments. We had examples of multi-billion-dollar investments. And then late in the life of the patent, often sometimes after the patent changes hands and is owned by a new company, that defendant is sued for infringement and suddenly finds that it has a very large business at stake, that it's built up over time while the patent holder was essentially lying in wait. And as a result, its damages can be a lot higher, and also its ability to avoid liability by, for example, choosing another technology or switching over to another technology can be a lot those steps can be a lot more difficult to take where there's been this sort of unreasonable delay. We also talked a little bit about the particular problem of unreasonable delay in suits brought by non-practicing entities, which is a term that is sometimes also referred to as patent trolls, but companies that basically don't make anything of their own or produce or provide any services of their own, but instead acquire patents, often late in the patent's lifetime, and use those patents to extract either settlements or verdicts against companies that have been using those technologies for years without ever being accused of patent infringement.
Great. And Professor LaBelle, what do you make of all this?
Okay, well, I'll just say a few words. So I am I think, neutral observer here. I did not participate in any of the amicus briefs, and unfortunately, I didn't have an opportunity to attend oral argument this morning. But I have a few reactions. So I guess my first reaction, and maybe the most important one, is I think that the focus on Petrella is misplaced. I think there's a lot of time being spent on Petrella, and I think the statutory language is different, and that seems important to me, that in the Copyright Act, the relevant provision was a true statute of limitations provision, and I think there's a lot of, at least in my mind, there's a lot of questions about whether this is a statute of limitations. It's not a traditional statute of limitations. As you can see from the language, when you usually think of a statute of limitations, it gives the plaintiff a certain amount of time from when the claim accrued to file a lawsuit, and that's not what happens here. It's just about a limit on damages. So I think the statutory language is different. And as we heard, the legislative history is different, and there are policy reasons it's different. But I think this case, I would hope that the justices focus not on Petrella and focus more on the facts of this case. And then I think my second reaction is I'm usually in the camp of patent law is not special. But it might be here, or at least it might be not special, but it might just be different based on the history. And then my third, I guess, reaction, and this is maybe more of a question that I would throw out there, is when you're reading the briefs or attending the oral argument here and thinking about a lot of these issues, what I think about and what I've thought about in the past is in trademark law, for those of you who are students and studying trademark law, we have this requirement that trademark owners have to police trademarks. And this, to me, is really a question about whether patent owners need to police their patents. And that's what I think at bottom is sort of the question here. Should we require patent owners to police their patents? And I think my answer to that question is yes. So I'll stop there for now.
Let me ask one other. So another theme that's been in the court's patent jurisprudence, and Justice Kennedy has been the sort of lead sort of voice for this, is that it persuaded that there's a problem in the land, that the power of a patent infringement suit to hold up an operating company that might be have hundreds of millions of dollars sunk in the investment is so asymmetrical, where the company is a patent assertion entity or a non-practicing entity. And so I was waiting. It's in every time there's a patent case, it's always with the patent trolls. At some point, they get trotted out. But I'm wondering, to the extent that Mr. Rapaway's brief essentially advertises that aspect of the case, that latches is a necessary defense to stop the patent assertion entity from waiting until the optimal time to where a operating company is so invested in the technology that there's no way out other than to pay a handsome ransom, I think would be the argument. I'm wondering, petitioner had a response to that. What was petitioner's response to try to allay that concern that latches is not a necessary defense against these entities?
Yeah, so the argument is, look, here's Section 286, that gives a cap on damages. So if a troll's out there or a practicing entity, someone's lying in wait, all they get is 6 years under the patent damages, which says you get a reasonable royalty for your patent. So we don't get the full 20 years, we don't get 10 years, all we get is 6 years. That's Congress's compromise, where they said, okay, the way we can figure out what's going on here and stop these trolls or whoever is have a 6 years statute of limitations, which will apply to damages, and say all you get is 6 years of damages, and that will sort of allay those fears in some way, not completely, but allay them to some degree, and so we won't give it the entire amount of damages that have ever occurred on this patent infringement.
And there's also the FTC report, which I'm wondering now, maybe Mr. Saunders or Mr. Rapaway, the argument petitioner makes is the FTC report suggests that patent assertion entity acquires the patent late in life. All of the economic incentives are to bring that suit quickly. Time is running out. And so a latches defense is really beside the point if your real concern is about patent assertion entities. I'm wondering what your view is on that.
This is probably more up my alley, given the way we did our brief. So I think that the answer to that is that we're not merely concerned with the amount of time that the patent assertion entity itself holds the patent, but with the conduct of the patent holder over the whole life of the patent. And I also, maybe an illustration would help. So one of the case studies that we discussed in our brief involved a patent that allegedly covered the use of JPEG images which I assume most of you are probably familiar with that form of display for images on the internet, to sell products on a website, which everyone in the world does. But allegedly there was this patent covering it. The patent was previously owned by General Electric, and when General Electric owned that patent, it did not take the position that it got to sue everyone in the world who was displaying JPEG images to sell their products on a website. But time passed, and the patent got sold as part of a portfolio. I don't know the exact chain of transactions. And years later, a non-practicing entity acquires that patent towards the end of its life, admittedly. Now, they certainly had an incentive to sue once they got the patent. But the companies that were out there that had been using this technology for years, and we gave one example of our client Dell that had been using this allegedly patented technology or process on its website for 10 years at that time. When it started, it would have been very easy for it to choose another technology if anybody had come to it and said you're infringing. Also, when it started, it was maybe $1 million a year website. By the time the patent assertion entity actually brings the case, it's $1 billion a year website. I'm generalizing, but roughly that much. And so the amount of damages in the reasonable royalty are far higher as a result of that delay, which in part was the result of the fact that GE didn't bring suit. They didn't have any bad intent. But we still would say that delay can and should be attributed to the patent holder for purpose of determining whether they can now come and sue Dell and argue for reasonable royalty on that $1 billion a year website, as opposed to having been obligated to police the patent back in the day, back in 1997 or thereabouts, and either come to an agreement with Dell or bring their suit promptly then.
And just so I'm clear, it's your view then that under the doctrine of, I thought laches was a personal defense to the party. Your view would be that the predecessors in interest behavior could be relevant evidence for a laches defense?
It's personal as to the defendant, in the sense that the defendant has to show prejudice from the delay. But we would say it is not personal in the sense that when the patent is sold, all previous delay is wiped out. And I think actually that even counsel for petitioners at argument was basically on board with that proposition, although obviously he doesn't think it applies to patents at all. But he would say that for purposes of estoppel, for example, conduct of a previous owner of the patent is attributable to the later owner of the patent. And I assume I know the same is the case for other equitable defenses as well.
Okay. I guess a question for Mr. Saunders. So there's a brief by some other law professors supporting the petitioner and taking more of a constitutional view that laches is a court-created doctrine and that and that there's a separation of powers problem with courts overriding the congressional intent expressed in this statute. And you take the position that there's no constitutional problem, that Congress intended laches, and especially for the benefit of our students, some of whom are just in their first year, can you help us understand the rationale? How do you get to that position? Because wouldn't Congress have said laches if they meant it?
Right, and I think there are sort of lots of different ways this can come up when Congress is approaching an area where there's a settled rule. Sometimes Congress, and we think this is what happened here, it's trying to codify a particular rule. And this goes back to what I was talking about before, how they use the general umbrella term unenforceability. Also, you have situations in which you may have a provision with a settled interpretation, and when Congress is reenacting that provision without change, we will generally presume that Congress was aware of the prior interpretation and didn't mean to change it. So one of the things we'd say about this case is, even if Section 282 wasn't affirmatively creating this as a defense, Section 286, its precursor, was understood for more than 50 years to be able to operate side by side with laches. And so the idea that Congress has exclusively spoken to the timing of these suits isn't correct, the courts were saying. And Congress came along and essentially reenacted the same statutory language without disagreeing with that interpretation. And so there's a presumption there. So we think that the fundamental setup of this case is so different from Petrella, because in Petrella, what you had was, for the first time in 1957, Congress was enacting a classic statute of limitations. And the question in Petrella was, could a judge-made doctrine trump that? And we think that the lessons of Petrella in terms of honoring congressional intent and separation of powers support us here, because we're trying to honor what we understood Congress to have done in light of that history.
Okay, and your authority, I mean, another thing, the students are all working with their authority, and you mentioned that about 98% of the cases were in equity. So we talked before about how law and equity were separate, literally separate courts, and so these cases were being brought in equity courts, not in the law courts for damages.
Yeah, for a period of time, and I think this was actually overlooked at argument, was the courts were overwhelmingly being brought in equity until 1938, when the distinction between law and equity was abolished. And then they kept applying laches. And so by the time that Congress reaches this decision of what to do in 1952, you have another 14 years of merged civil procedure in which they're still applying latches. And so I think we would say that if they were going to unscramble the egg, that would have been a logical time for courts to be saying, wait a minute, that was an equity specific rule, as opposed to something that had become more generalized for patent law. And then we also look forward too, which is there's the 1952 statute. And then what has happened between then and now? Every single court of appeals to consider the question kept applying latches to bar damages, including people like Justice Stevens when he was sitting as a circuit court judge, including Associate Justice Clark when he was retired and sitting on the circuit. And so I think we are alarmed at a line of argument that would take a legal rule that is now essentially 120 years old and be throwing that out, because in that time, even though you've had over a century of unanimity in the Court of Appeals, the Supreme Court hadn't happened to touch that rule. And we don't think that that is sort of good for the development of the law, and also isn't the way that Congress would have been thinking about it when it was trying to codify settled law, and there's a consensus out there, and the treatise writers are saying the same thing.
Professor LaBelle, I wonder if the Chief Justice and Justice Ginsburg didn't quite agree, or at least the Chief Justice seemed to, Mr. Waxman said, I've got a mountain of cases that support the proposition you just heard. The Chief Justice said, I can only find 4 that were actually in the law courts. And so your mountain is now a molehill. Is that the best you've got? And I wonder, Professor LaBelle, are the judges right to sort of think only the legal cases are the right precedent, or should the equity precedent be relevant to this statutory interpretation question?
Well, I mean, I would think, I know, going back to your earlier question about the law professor brief, another point that they make is about, they say, patent law is not different, and the general rule is that latches doesn't apply to a legal claim when there's a relevant statute of limitations. So I still think it comes back to this question of whether there's a statute of limitations, because statute of limitations, and one thing that makes me think this is not a statute of limitations, is that statute of limitations are not supposed to simply limit damages, as Professor Anderson was saying earlier, that petitioner's response would be, well, the damages are always going to be limited to 6 years. So even if the patent owner waits many, many years, the damages are going to be limited. But that's not, statute of limitations are not just supposed to limit damages. They're supposed to sort of give a sense of peace to a defendant that they're no longer going to be sued. So I think, I'm not sure about the particular discussion that you're asking about with respect to the Chief Justice, but I would think after that, you have to look at all of the cases. You have to look at not just the legal cases or the cases involving damages, but the cases more generally, because there's in the way patent law has developed since the merger after the adoption of the Federal Rules of Civil Procedure in the 1930s. In most patent cases, there are legal claims and equitable claims. And so I would imagine courts aren't always drawing distinctions when they're applying a latches defense and being very precise about whether that defense applies only to the equitable claim or whether it applies to the legal claim too. So I would imagine that the court needs to look at all the cases.
Let me just comment on that. Whether or not this is a statute of limitations is it's an argument that takes a lot of finesse, because if you read this statute, it does limit the damages in the same way that a statute of limitations would. And we're talking about here is a repeated tort. You sell one item, you sell it every year, every day, and every single one of those actions infringes the patent or could infringe the patent. So a statute of limitation versus this wouldn't have that much of a difference in application. So I think the difference between, saying this is not a statute of limitations is a really fine argument, and one that I don't think was latched onto at all today. And even Seth Waxman, I think, kind of gave it away, kind of understanding that he didn't need to win that argument to win the case.
Yeah, which I think is certainly true, because we didn't win that argument below, but won below. But if I could just sort of take a stab at articulating, I think the difference is that this is the 6-year look back period doesn't speak to the issue of knowing delay. It's just a fixed period, and it's going to keep marching forward and cutting off your damages, regardless if you even knew about the infringement. It's not case specific. It's just an across the board. In that sense, it's a little bit more like a statute of repose. It's running backwards rather than forward, but it's this absolute period. A traditional statute of limitations, like the statute in the copyright context, is tied to accrual. And most of the courts of appeals in copyright have applied a discovery rule. So your claim doesn't actually accrue until you discover the infringement. So that statute, like latches, speaks to the issue of knowing delay. It's sort of your claim has become mature, you know about it, or you should have known about it, and you're still not taking any action. And so it's easier to say in Petrella, sort of a statute of limitations like that and latches speak to the same thing, and so is there room for latches? Whereas for this absolute 6-year period, we like to say it's the backstop. It's out there. It's going to cut off if you've gone more than 6 years, but it leaves a gap that can be filled by a case-specific and fact-specific rule. The other thing is I think that something that got overlooked at argument today, that there was some exploration of it, some aspect of it, was that in addition to the potential differences in the statute of limitations itself, there was a long discussion in Petrella of copyright law. The portion of the opinion that was saying latches doesn't apply to actions at law was actually just a few paragraphs. And there was a long discussion of other copyright provisions that were giving the court comfort that there would be this type of delay. And so something that we argued in our brief, but that only came out a little bit with questions of Justice Breyer at argument, was all the other differences between patent and copyright that we think would lead to different results here. One of the striking things about copyright is you have a reversionary right, so that if the author has died and the heirs can then get the second period of copyright, it can undo a lot of the agreements you had earlier on. So one of the things the court talked about in Petrella was that there's a sort of already a tremendous tolerance for delay built into copyright. Something that did come up today was you talked about the differences between copyright, where you have to have copying, and patent law, which is a strict liability offense, and where there, I think, objectively, there can be difficult decisions in copyright, but I think that the difficulties people face in patent law in terms of figuring out whether you infringe or not are much greater in terms of the sheer number of patents that can cover a product, in terms of the ambiguity of those patents. And so there's a lot more risk of people going along and then being caught out once they've made all these investments. And the other thing we tried to invoke at argument 2 was Petrella specifically said, well, we're not worried here about anybody who bought a Raging Bull CD because they're not covered by copyright. Because if they're watching it in their house, it's not going to be a public performance. Patent law is different. Patent law protects the right to use. And so even the person who is buying the end user, unless it's been an authorized sale and there's patent exhaustion there, could continue to infringe. So it's interesting because if you march through Petrella, sort of almost every copyright specific reason given in the decision doesn't apply to patent law, but there really wasn't a lot of focus. It was almost like that wasn't in the opinion today, and it was just this focus on where does latches fit and how does it interact with legal damages.
Right. So you guys are working on how you analogize and distinguish cases. That's how you do it. Mr. Rappaway, maybe help us understand, you were in the court today, so help us understand why did the court take this case, and what was the reception of these different arguments from your understanding? You have an interest, but as an observer of the court, as an institution.
Okay. I think, as to why the court took this case, there was the decision below was taken en banc by the Court of Appeals, meaning that all the judges on the Court of Appeals heard it and decided it together. And the en banc court was very narrowly divided. The view prevailed that we support that laches remains a defense in patent cases prevailed by only one vote. And I think that the court was probably took the case because there was a narrowly divided decision below, and there was at least a reasonably a colorable argument, let's say, that it was in conflict with Petrella. And so the Supreme Court will often grant review when it feels that the lower courts are not paying attention to its prior decisions. And that is, and so probably that combination of a close result below, an important question, and an arguable conflict with a recent decision of the court was what caused them to grant. Now, I think one thing which certainly those of us who supported respondents were concerned about going in was whether the justices really were going to take the view that this case was controlled by Petrella and that there was not going to be that much to talk about at argument. And I think with the exception of Justice Ginsburg, who was the author of Petrella, we did not really see that kind of commitment to the proposition that Petrella already decided this case. I don't think that necessarily means that Tom's client will prevail, but I think that we got over that first hump, which was convincing the justices that there is a new decision here. This isn't just an easy reversal in light of Petrella. There are things to do. There's, as Justice Breyer said at one point, there's a lot of cases to read if they're going to address the historical arguments. So if they're to the point of reading the cases and trying to figure out whether the history actually supports drawing a distinction between patent and copyright, as well as the policy arguments also, we would say supporting that distinction. That is a good sign, I think, for respondents. Now, getting into the question of which justices in particular might be available votes. I mean, do you want me to
Sure,
talk about
if you're
that a little
willing to,
bit?
absolutely.
I mean, this is always very dangerous to do after an oral argument because you only have a few comments by each justice, and you have to draw a lot of inferences. But one thing which court watchers do is try to count votes. I think we can probably say that Justice Ginsburg is safely a vote for petitioners. I think we can probably say that Justice Breyer is safely a vote for respondents. And he seems to be adhering to his dissent in Petrella, although he said that he would accept Petrella as good law. But I think from a sort of at a gut level, he was still persuaded by the arguments in his dissent. The two other votes that were in dissent in Petrella were the Chief Justice and Justice Kennedy. Justice Kennedy, as I recall, did not speak during argument.
Yeah.
So we don't really have any data, but we can maybe assume that he still feels the way he did when he wrote his dissent. The Chief Justice was active, and I think his comments went both ways. He had some discussions with counsel for petitioner that didn't sound so good for petitioner, but he also had some discussions with counsel for respondents that didn't sound so good for respondents. So I think his vote is tough to predict after oral argument. He's up in the air. We did not hear anything really substantial from Justices Thomas or Alito, who were
Thomas for sure.
No, nothing from Thomas. And I think Justice Alito may have said one or two things,
Yeah,
but
there's
not a
one
great deal.
question.
Okay.
You had one question at the end, just sort of
Yeah.
understanding how damages work.
Okay. Maybe we can make the same assumption we did with Justice Kennedy and think that their votes probably are likely to be on the same side as they were in Petrella. Maybe not, but that would be an assumption. And so the two votes that really might be in play are those of Justices Sotomayor and Kagan. And I think Justice Sotomayor more than Justice Kagan. Justice Kagan was not a very active questioner, so it's hard to say much about her views. She did have one comment during the rebuttal argument, one question that was helpful to.
Yeah, I have it right here. She says,
excellent, thank you.
Mr. Waxman's principal point is that what separates out the patent context is that Latches was operating in true equity, but with the statute of limitations, and that just wasn't true in other places.
Right. So the fact that there was this coexistence between a statute of limitations and the equitable doctrine of Latches in this particular area of the law, which is a principled basis for saying that patent law here is different from other areas of the law, which that certainly was a good sign. And Justice Sotomayor, I think, asked a lot of questions on both sides. So as with Justice Roberts, I would say she's probably up in the air, but we at least saw some openness to the possibility that she would not simply adhere to her position in Petrella and extend it to apply to this case.
I mean, for the students out there, the rule with Supreme Court cases is you just need 5 votes. But now with Justice Scalia having passed away, you just need 4 in the case of respondents. So all they're trying to do is get 4 justices to agree with them, and they have 3 that dissented in Petrella, so that is 1 they need to get.
Yeah. I mean, we'd love to have 5. So that would make the law clear and settled in our favor. If it's a 4-4 decision, then that just puts it off till another day. But, getting 4 is better than getting 3.
Right.
So.
Well, let's open it up to questions. Do folks in the audience have Professor Farley?
So I'd like to speak about trademark law.
Shocker.
Thank you, Professor Lavelle, for raising it. So I wrote an amicus brief to the court in 2013 urging the court to grant cert in a trademark latches case. They denied, but that was the year that they took the Petrella case. And that case involved a 40-year period of latches and acquiescence, which was upheld. But the remedy was no damages but an injunction. And there's a circuit split in the case of latches in trademark law about what effect that has. So just to let you know, there's a mess in latches in trademark law as well. And there could be round 3 of latches and IP. So it really has me thinking about the distinctions between the 3 areas of law. Obviously, in trademark law, there is no statute of limitations or anything like a statute of limitations in the Act. But one of the things I wrote in the amicus brief is this is an important thing to settle because, in fact, in trademark cases, latches is raised as a defense in 2/3 of the cases. So we could talk a lot about the differences between these areas, but I don't have any sense in patent or in copyright, like how much of a defense, how important of a defense is this? How regularly do you see it? How important is the policy work it's doing? I take it that was the point of your amicus brief. But is this a regular occurrence as we see in trademark law, latches defense?
I think that's one thing that's in favor of the respondents here is that every case that I'm familiar with has this argument in it. It's not deciding, it doesn't decide many cases, but the judge has to deal with this argument in a majority of cases. I haven't seen numbers on that.
Yeah, I don't know that we have numbers on exactly how many cases. It's certainly pleaded very often.
Yeah.
I mean, I would say, but of course, with affirmative defenses, people tend to just stick them in their answers. Right. The question, the data that would really help answer your question would be how often is it actually litigated and becomes a real issue in the case. Yeah. And that, I think there were some I think there were some references to it argument, but no hard numbers. Yeah. We would say, we certainly came up with what we hope were helpful examples of cases in which it played an important role. And we felt it was not hard to find a fair number of those that were relatively recent. We were dealing with cases just in the past few years, just looking at published or, at any rate, opinions that we could find. And we still found a number that did, in fact, go off on latches. And these were fairly high-profile cases with large damage amounts being sought. So it was, I think, there's some basis to say that it's important in patent law, even if I can't answer the empirical question of how often it's litigated.
When studying that, did you compare that to copyright law to see if it was, in fact, more important maybe in patent law than copyright law?
We did not do that comparison.
Yeah. I can say in copyright law, it's pretty rare because, one thing that's interesting is what's the evidentiary level that you have to bring in order to succeed on the defense? And at least in copyright, to avoid the idea that the trademark owner has to police their rights, copyright plaintiffs are given quite a wide berth to decide when it's economically feasible and worthwhile to bring the case. And so if that's the reason for the delay, unless there's some pretty good explicit evidence of reliance by the infringing party, the latches defense is unlikely to succeed. Estoppel's generally a better argument.
Because it seems to me that's an important policy reason to have a different rule in patent law, right? If it's a doctrine that people routinely rely on in patent law, and that's not the case in copyright law, then that's a reason that Petrella should not be followed.
I don't get the sense it's a doctrine that people routinely rely on, at least to the beyond the pleading stage. But I do wonder, and I don't have any empirics for this, whether it's become more common with the rise of patent assertion entities. I don't know if anyone else on the panel has a sense of that.
Well, we do have empirical data that patent assertion entities do tend to bring cases much closer to the end of the useful life of their patents, and that you see a real distinction. We cite some law review articles and some other studies between operating company suits, which tend to come earlier, and patent assertion entity suits, which tend to come later. So to the extent that the amount of patent assertion litigation has increased, and there's separate studies showing that, then you can put those two things together and say, well, yes, there must have been a lot more cases being brought towards the end of the patent's useful life because there are all these patent assertion entities running around out there now. Excuse me.
I also think that because the two main justifications that are given for latches are economic prejudice and the evidentiary prejudice. And so something you see in patent law is you get to some really eye-popping figures in terms of the economic prejudice. So the amount of investment that can happen during a delay. This certainly happened to our client. He was building entire factories, or the Dell example, think of the scale up there. And then the other thing is, in terms of the evidentiary prejudice, one of the things Petrella said is it said, well, the burden is going to be on the copyright holder, and delay is going to work equally to their disadvantage. And I thought that was brought home right after Petrella was decided. The suit was filed against Led Zeppelin, the one that got a lot of press coverage, trying to claim the opening to Stairway to Heaven. And the trial there, I didn't read the full transcript, but by all means was just a bunch of people saying, I can't remember anything from the, I mean, so it worked against the person asserting because they had a lot of trouble proving copying because of the extreme lapse of time. Patent law, you're going to come in and you're going to get them on your strict liability. I just care what you're doing now. And much more than copyright, the validity case is a very robust part of the patent case. And so it's hard enough under ordinary circumstances to litigate a public use defense where you're not looking to some prior publication, but saying you showed this at a trade show 8 years ago. Now, if you wait even longer, then they're trying to prove you showed this at a trade show 17 years ago. Good luck with that on a clear and convincing evidence standard that you'd have for patent invalidity. So I think that was another of the potential policy differences that would speak to saying maybe we should have a different rule here in patent law.
Any other questions? Well, let me ask Mr. Saunders a lawyering point for more general, that where the court grants a case like this in the wake of Petrella, there is at least an implication that this is merely an exercise in correcting the lower court in their failure to read Petrella correctly. As you take on the burden as an advocate of fashioning a way to distinguish one of the court's own prior cases, without revealing any confidential information, but just in general, how does an advocate in your position sort of start to think about the lines of argument that are most likely to be persuasive about why this is different?
Right. So it's a very good question. I mean, the first decision that you have to make is coming to acceptance with the old decision. Because it's very easy to come look at this and say, wait a minute, what Petrella doesn't make sense to me. And you're going to instantly put yourself into an uphill battle there if your argument depends on reversing prior precedent. So you are right that the question is, accepting that case, how do I get around it? And I think that the sort of way it follows the ordinary hierarchy of statutory interpretation here is that the first thing you want to look for is some textual provision. And then you can look for the context and the historical backdrop. And even though they are important in the end, I think the weakest arguments are the straight up policy arguments. If we were just making the abstract, we think there should be a different rule for patent law, it's much easier for the court to say, well, we're just going to apply the general rule here and we'll kick it over to Congress. So you have to make sure that when you're making policy arguments like that you're grounding them to something in the statute, whether it's the text of your very provision or whether it's the context there, that makes it something that the court can feel that it can act on. And so I think that you sort of think of all of those lines of arguments, and it's not one or the other, but it's weaving them all together into this story of going in a different direction here.
Great. If there are no other questions, any parting comments, parting observations?
I mean, I just would say that the court, to me, there were sort of questions. It was a relatively quiet session today. The court has had a lot of patent law. I mean, they have 3 cases this term. By my count, it's been 22 patent cases in the last 6 years. They have another case where the Solicitor General is recommending grant, so we could easily have a 4th. And depending what happens in December, possibly a 5th patent case this term. So it's been a lot of activity at the Supreme Court, a lot of things that are in motion at once. And so for people who are interested in this area of the law, it is a very interesting time to be practicing it, and one that requires a lot of creative thought, because ultimately you're talking about a body of law that is all about balance in the end. It's getting the right balance between the incentives without tying up freedom to operate here. And so that's an area in which you might think that you would tweak one side of the scales, you'd tweak another, you'd wait for it to stabilize and do it. Here it's 22 times the weights on and off all in a 6-year period. And I think there's a lot for people to keep in their head and map out and try to understand how all these other changing doctrines and shifting, not to mention a new statute from 2011 coming online, all work together. And so I think there's still a lot more questions to work out, and we're going to see a lot more action still in this area.
Just come on down.
So I will say that even if the justices didn't seem to care that this is not 286 is not a traditional statute of limitations, I think it's really important because I think Congress hasn't thought about what should the statute of limitations be for patent infringement. And for that reason, I think it's very important that latches continue to operate in this space, because I think it's different than in the copyright context where Congress has sort of thought about what should the statute of limitations be. That hasn't happened here. And I think latches continues to play a really important role when we have certain factual situations where patent owners just wait too long to bring an action. So that will be my parting thought.
Well, my clients would certainly agree with that. I do think that to the extent. This is an interesting case, in part because I think the evidence as to what Congress actually would have expected or believed would happen in 1952 is really all on one side of the case, Tom's side of the case. That may not prevail. What we heard expressed very forcefully at argument today by Justice Ginsburg was that she thinks there's a background rule, a background principle or maxim here that pretty much governs in this area, and that unless Congress tells her very clearly it doesn't apply, that by creating a statute of limitations or anything that looks sufficiently close to a statute of limitations, that displaces latches. So I think for that reason, this case is sort of interesting theoretically, in that it. Even though every justice in the court would agree this case is all about congressional intent, that congressional intent governs here, what that means and how we determine congressional intent and whether we determine it by looking at what actual members of Congress were thinking at the time is very much an open question.
I'll say this is, even if you don't care at all about patent latches, and I don't know why you wouldn't, but you should care about this case because you should care about the Supreme Court and what's going on in this case. So taking Justice Scalia out makes a big difference in this case. Just trying to get to 4 votes is a lot different than trying to get to 5, which they'd be trying to do if Justice Scalia or someone else was there. So it's all about how cases are prepped, how they're brought before the court. All you're trying to do is get 5 votes. In this case, you just want 4. And so how do you think about which justices flipped, which think Patella controls, which don't think Patella controls? I mean, that's going to really decide this case. If the same four agree that Pachella controls, I'm going to win. If one judge flips and doesn't think Pachella controls, they're going to win. If three judges flip, they're going to win. And so that's really what the lawyer is doing. They don't, well, I don't want to say they don't care about the policy, but all you care about are the votes that you need to get to win the case.
Yeah. And I'll just close. I mean, it is fascinating that the court continues to get very interested in patent law. It clearly has a couple of reasons for it. One, as an equally divided court, the speculation is they want to avoid taking questions that where there's a likelihood of a 4-4 split. And so the commentators early on said, well, intellectual property, that's a safe place. It's non-ideological. If you get a 4-4 split, it won't be on political party grounds. It will be on sort of other forms of judicial philosophy. But they also really do understand that intellectual property is an important part of the American economy. And that having centralized so much appellate power in the Court of Appeals for the Federal Circuit, the Supreme Court has taken these 22 cases in a relatively recent time because the Court of Appeals had a long stretch without much review. And so there are a lot of questions that are now popping up and getting answered. So, I agree. This is a fascinating time. And I can't predict on this one. I think, it's a little hard. I think whether Justice Ginsburg can persuade the others that there is a general principle Congress needs to speak, as opposed to really getting into the details of the history here, that will be one of the keys, I think, to how this comes out. So thanks everyone who joined us on the internet and in the room. Please thank our panelists for this lively discussion. And we invite you to join us for a reception outside.
Thanks, Greg. Thank you. Pleasure.
Nice to meet you.
Oh, is it?
I was afraid you were going to take the ejector route.
Well, I almost always take that position.
No.
Yeah, I do too.
The question is, are we going to know in record time? If it's a full court, we can know within a week.
That's true.
It doesn't always happen. Sometimes they try to hash it out, and then they can see they can't do it. But,
They're not still taping us. So.
Yeah, the mics maybe.
Yeah.
Put us on.
Thank you.
I don't think so. No.
Did you read that?
No, just saw email. It's been a great day for me there.
I sort of felt like I should be representing petitioner or defending petitioner's position. I'm going to keep it equal. That's not.
We're a little upset. So,
Kim will hear
No,
just sniping.
That's for, yeah.
Oh, yeah. She's a worker. So she's clerk. She's great.
Yeah. No, she's a great patent professor. You'd expect it to be very, dry, always very enthusiastic, so.
Yeah. I mean, there's a lot more going on in patent law than people realize.
Yeah, yeah.
So,
It's interesting, honestly.
Yeah, I actually listened to I think it was like a TED Talk the other day
Yeah.
about patent law. I was like, oh, it's trending now.
yeah. That's all right.
Did you see the